Assalamu alaikum and welcome to the first episode of Legal Ease, the show that translates legalese into English. I'm your host, Yumna Bhana, and along with my learned guests throughout the series, I will be guiding you through legal issues which we regularly encounter. To get us slightly more acquainted, I'm a qualified attorney practicing insolvency law at Edward Nathan Sonnenberg's. Law is often considered unreachable with its technical language and what appear to be complicated procedures and terms. This is really a disappointing reality when we consider that law forms an essential pillar for society by governing its actions and providing guidelines to be followed with regard to different aspects of civil existence. The law aims, in part, to assist and protect the citizens of South Africa as we go about our lives. The result of the misconceptions created about our legal system is that people are often ill-informed about their rights, they don't know how to access the legal system, and they lack an understanding of basic legal principles which we encounter daily. Unfortunately, this does lead to situations where people make uninformed decisions, they inadvertently end up on the wrong side of the law, and they can be open to abuse. With me in studio to explain some of these concepts is Mr. Ashraf Essop of MA Essop Incorporation. Mr. Essop was admitted in 1991 as an attorney. He has a BA LLB degree from the University of the Witwatersrand, and he is eligible to be registered as a solicitor in England and Wales, having completed the QLTT. Assalamu alaikum, Mr. Essop. I'll call you Ashraf for the rest of the show, and welcome. Thank you so much for taking the time to be with us today.
Wa alaikum salam, Yumna. Thanks for having me.
Now, the Constitution is the cornerstone of our society. It's the overriding governor of law and the legal system in South Africa. This hierarchy translates directly into the hierarchy that we see within our court structure, with the Constitutional Court being the highest court in the country. Ashraf, can you take our viewers through the basic court structure in South Africa?
Certainly, Yumna. The highest court in the land is known as the Constitutional Court, which sits in Johannesburg. It was established in 1994. The Constitutional Court has got 11 judges. They are tasked with interpretations of all matters dealing with the Constitution itself. So you have a Constitution and you have constitutional rights, all embodied in the Constitution. And any interpretation regarding any aspect of that particular Constitution is the exclusive paradigm of the Constitutional Court. Below the Constitutional Court, and that judgment of the Constitutional Court is binding on all other courts, flowing down from that particular hierarchy that you spoke about.
Ashraf, I think people often think that any matter can be taken to the Constitutional Court, so that will always be their final line of getting a remedy. But there are matters where the Supreme Court of Appeal will be the final court. Can you just explain to our viewers what the difference between constitutionally related matters are and your general matters?
Sure. As I've explained, matters affecting a person's constitutional right can be taken to the Constitution itself. Now, it could be done privately or it could be done through a particular entity, an attorney firm, etc. But, for example, today, a matter was argued in the Constitutional Court by the plaintiffs directly, which we will deal with a little bit later. So, their rights to a constitutional relief in terms of the National Credit Act was something that affected their rights as people. And they had the power and the ability to take this through the legal hierarchy, and then ultimately sitting with the Constitutional Court itself, which then pronounced on this matter today. Right. Just directly below that, you will have the Supreme Court of Appeals. Now, the Supreme Court of Appeals doesn't normally deal with constitutional matters, although it can. It's a lower court, but it deals with all other matters of a non-constitutional nature. So it was known as the Appellate Division in the past. Now it's known as the Supreme Court of Appeal, and it sits in our judicial capital, which is in Bloemfontein.
In terms of selecting where there is a choice, what would be the difference in either choosing to approach the High Court or the Magistrate Court?
Well, there's jurisdictional requirements for both. For example, in the Magistrate's Court, you could take any matter where the amount is 300,000 rands maximum. Alternatively, irrespective of the amount, and if the parties have previously agreed that the Magistrate's Court will have jurisdiction to hear their dispute, say of a contractual nature, irrespective of the amount claimed, then they'll be entitled to take it to the Magistrate's Court. But let's say you're claiming 300,000 rands in the High Court. Yes, you can institute action for that. But in the event of your winning the matter or you're succeeding in the matter, you could expect that the High Court might say, I'm only awarding you costs on a different scale, which is the costs in the Magistrate's Court. So, what cases cannot be heard in the Magistrate's Court? Those are specific. They deal with matters of capacity and, for example, insolvency. Now, insolvency deals with your capacity.
Yeah, so, and here we'd specifically be talking about sequestrations, which affect the personal status of an individual.
So therefore, only the High Court would have jurisdiction to deal with that.
Right.
Now, the High Court, while you have children's courts and maintenance courts, the High Court, for example, is the upper guardian of all minor children. What does that mean? That the High Court can pronounce on matters that deal with children, even against the wishes of a particular party, even if it's a parent or guardian. So it has that protective element in it. It pronounces on matters of, let's say, of a personal nature, which other courts, for example, the Magistrate's Court, might not be able to do.
Welcome back to Legal Ease. We're discussing basic legal concepts, and I've got Ashraf Essop with me in studio. What we were discussing before the break is the structure of courts in South Africa, and we'll be moving on to the Small Claims Court. Ashraf, the Small Claims Court has a very different way of operating from your standard court, and it's aimed to provide a very quick solution to, I'm going to call them small problems. They may not necessarily be small to the people who are experiencing them, but to provide a cheap and quick solution to legal disputes that parties may have. Can you just explain to us how the system works?
Yes. The Small Claims Court is a very innovative concept. It's almost like street law. The Small Claims Court has got jurisdiction to hear all matters between parties that doesn't exceed 12,000 rands. But you also can't take matters of personal status like adoption and insolvency that we spoke about. Usually, it's there to adjudicate disputes between the parties for amounts not exceeding 12,000 rands.
So no legal representation. You come yourself, you bring all your evidence, you put everything together, you bring your own witnesses.
That's right.
Just to explain the concept of jurisdiction to our viewers, jurisdiction it basically refers to the manner in which, or it's an overall catchphrase explaining how we come to where or which court a matter should be brought in, or which court has authority over a certain issue. What are the factors that govern jurisdiction?
There are various factors, Yumna. For example, in a maritime matter, the coastal courts will have jurisdiction because the vessel is usually docked in their jurisdiction. So jurisdiction really refers to a geographical limitation to that court's influence.
Another element to consider when considering jurisdiction is the type of matter that you're bringing. For example, where you've got a delict or most of your civil actions, your jurisdiction will be based on where the defendant is found or the defendant's domicilium. Maybe just explain the concept of domicilium to our viewers.
Okay, that's interesting. Usually, if you are domiciled within the area of the court physically, for example, in a divorce matter, traditionally the court will want you to be domiciled or living within that area of that particular court for a period of 12 months prior to your bringing of the action.
What is the situation with jurisdiction when it comes to foreigners?
Okay, foreigners are known as peregrini. So they are foreigners of the Republic of South Africa. But you get two kinds of foreigners. You might be a peregrini of a particular court. For example, if you're residing in Cape Town and the plaintiff is residing in Johannesburg, you would be considered a peregrini in respect of the Johannesburg High Court, for example. Now, foreigners bringing an action in this country, because they would have no means of satisfying an adverse judgment, are required to put up security for any action that they bring. Now, previously, you could bring an action to arrest a foreigner. Now, the reason for that was the courts itself didn't have jurisdiction over the foreigner himself. That kind of arrest is now no longer constitutionally viable. However, you can attach property belonging to the foreigner and bring that to the court's attention that I'm now attaching this man's property. It is within your geographical region. Therefore, this particular court has got jurisdiction to hear that matter.
That the issue of attachment again brings us to the issue of the sheriff. Let's just discuss what the role of the sheriff is in our judicial system.
Okay, the sheriff is appointed by a particular act, and again, we're talking about jurisdictional boundaries. Each region has a sheriff. So you could have, say, the sheriff of Central Johannesburg for the High Court, and the sheriff for the magistrates court, or the messenger for the magistrates court. So each particular area. Now, the sheriff is entrusted with the execution of all court orders. The sheriff is also regulated by certain acts, and there is a sheriff's board in the event that you find that the sheriff has not complied with his obligations. You can always refer the matter to the sheriff's board. But the sheriff's duties, for example, are to serve the summons on you, to attach your property in the event of a judgment. Let's go back to the small claims court as an example. If you've obtained judgment in the small claims court for your maximum 12,000 rands, and the defendant hasn't come, you can now issue what we call a writ of attachment out of the magistrate's court. But you yourself can't take it to the defendant. You have to hand it to the sheriff, who will charge you a small fee to deliver that document to the defendant. Now, what does he do with the document? In the event of an attachment, he would make a note of whatever property belongs to that particular defendant. So that property becomes attached by the sheriff, and then going down through the process, once the attachment is perfected and there is no opposition to it, the sheriff is entitled to sell it at the sheriff's auction.
Right, so the sheriff is the actual bad guy in the end. Does all the hard labor.
Yeah, he seems to have been the good guy only in the movies. The sheriff here.
Yeah, the American movies. Yeah. The sheriff with his big gold chain. The reality is very different in South Africa, and sheriffs do have the hard task of fulfilling judgments.
Absolutely. And the integral part of the legal system.
To allow some time for that information to digest, we are going to take a short break. Welcome back to Legal Ease. Just as a reminder, I've got Mr. Ashraf Essop with me in the studio. We just briefly want to discuss the issue of prescription. How long does a person have to bring a matter to court before they have run out of time?
The Prescription Act prescribes a period of 3 years. If you bring your action after a period of 3 years, usually you won't succeed because your claim would have prescribed. That means you've run out of time.
All right. I think just for the average viewer to understand what the difference between a civil matter and a criminal matter is in terms of how it's brought to court and what remedies would flow from that. I think crime is a big problem in this country, so lots of people have been victims of that, and they always want to see some kind of justice. What is the justice that would appear from a criminal matter as opposed to a civil matter?
Okay, usually in a criminal matter, the state prosecutes the matter on your behalf. For example, if you're a victim of housebreaking, you yourself won't have to go and sue the suspect and have him arrested. The state apparatus does that. The police would have him arrested. They would take him then through the criminal justice system. He may or may not apply for bail, and then he'll appear in court, and then the prosecutor will prosecute the matter on your behalf. So he's actually representing you, and then defense counsel will represent the suspect or the accused.
Ashraf, assuming, working on your example of housebreaking, cash was stolen, 10,000 rand and some valuables. In terms of criminal matter, what recourse would a person have to that?
Okay, usually the courts will pronounce the person guilty and find and impose a sentence in terms of the Criminal Procedure Act. There are certain minimum sentences now that have come into operation for serious crimes. For example, rape, minimum sentence is 15 years. In the civil case, for example, you would have what we would call restitutive relief. In other words, you can claim back the monies that were taken from you. It's not usual that you can sue a criminal for that, but that's the distinguishing feature between matters of a criminal nature and matters of a civil nature.
In a nutshell, what you've said is that a criminal matter punishes the offender, whereas a civil matter orders the offender to restore the position of the person that they have harmed.
That's exactly right. But there is a movement now in the criminal law for restitutive justice as well. For example, where you undertake to pay back, and the court has a discretion in that. Okay.
Another thing that I think confuses the public a lot, and I think ITV viewers would like to know, what is the difference between an attorney and an advocate, and what roles do they play?
Okay, traditionally the legal profession was divided into the roles of advocates and those people that are registered as attorneys. Now, advocates usually appear in the High Court and they belong to a bar council. You do have independent advocates as well, but advocates usually have a different level of training. For example, once they graduate, they can serve a pupillage for a period of 6 months and then write the bar exams. Attorneys might also be advocates, might have the rights to appear in the High Court as advocates, but usually they practice at the sidebar, as it's commonly known, or under the particular auspices of a attorney's counsel. Now, recently there's been a lot of talk in the press about the Legal Practices Bill, where all of the two professions will be amalgamated into one. So you won't have a distinction between attorneys and advocates. But a critical difference in how they practice is that usually an advocate doesn't see the client without an attorney. The attorney has to brief the advocate. The advocate himself can't go out and obtain an instruction from the client. He only obtains instructions via the attorney.
There is a very special relationship between an attorney and client, a very special legal relationship. Just explain what that is.
That's a very important relationship that you've just mentioned. the attorney and client relationship is governed by what we call privilege. So whatever you say to your attorney is absolutely privileged and confidential, and he cannot reveal what your instructions were to him in confidence. He can only reveal what you give him authority to reveal. Now, usually in the minds of the public, they always believe that the attorney is doing something wrong and he's shielding his client. But we as legal professionals have been taught that it's not your job to assist the state in its case. The state has to prosecute the case to the best of its ability, and you have to defend your client to the best of your ability. The state has to prove its case in any event. So that information that he might have given you remains absolutely privileged and confidential at all times.
Lastly, we want to discuss the differences between trials or actions and applications. And I think this is an important distinction to make, just because everyone's idea of going to court is getting into a witness box and having to give evidence and being questioned by an attorney or an advocate and being cross-examined. And there are two very different types of matters that we see, and they are applications and actions. Actions being your typical TV-type trial, and applications being different. Let's just look at those differences.
Absolutely. The application process is what we call motion court. Usually, that matter is argued and determined on papers before the court. So there's no evidence in person. So you don't appear and take the oath. You do all of that on paper. Now, that is ideal where there is no dispute of fact, where the facts are clear from the papers. In the event that you anticipate a dispute between the parties, it will not be advisable to go the application process. You must then issue the summons and let that matter proceed to trial in the normal way.
All right. The basic difference between your application and trial, applications tend to be much quicker because they're on paper. They're also a lot cheaper than trials.
Absolutely. Because if you just take into account, the application process could stop quite early in the let's say, the legal timeline, and your cost could be limited earlier on in the case. Whereas in a trial, you might have to go and wait 18 months or 2 years to obtain a date. There's a lot more paperwork. There's pre-trial procedures. There's trial procedures. There's the summonsing of witnesses. There's the collation of documents. And of course, the actual cost of the day of the trial, which could run into a few days. Whereas an application process, as we've said, is where the disputes are minimal and the matter can be adjudicated at the court earlier on.
Ashraf, we really appreciate you having taken the time to be with us today to explain to the viewers where they can find you and avail themselves of your services. You are practicing in Fordsburg, in Johannesburg.
That's correct, Yumna.
We hope to see you as a guest on the show again soon.
Thank you very much for giving me the opportunity to be here.
I hope we were able to make law a little easier for you to understand on today's episode of Legal Ease. Stay tuned for the next show where we will be discussing labor matters. Assalamu alaikum wa rahmatullahi wa barakatuh.